shoot it over to you. All right.
Okay.
Apurva, you can start recording. Sritej, you can start live streaming. And Sritej, let me know once you've started live streaming. All right. An early good evening to everyone here. Thank you for joining in for the series of webinars on the new labor codes. Before we begin, I'd like to introduce the organizations that are hosting this session and our speaker for today, starting with NSS. The National Service Scheme is a government sponsored public service program conducted by the Ministry of Youth Affairs and Sports. Popularly known as NSS, the scheme was introduced in 1969 with the primary objective of developing the personality and character of the student youth through voluntary community service. Very appropriately, the motto of NSS is "Not me, but you." NSS attempts to establish meaningful links between campus and community, college and village, and knowledge and action. The NSS unit of Government Law College Mumbai was formed 11 years ago. Our primary means of providing service this year has been through imparting educational online sessions. This webinar on the new labor codes, in collaboration with HRLN, is our latest effort towards that goal. And on that note, I'd like to now introduce HRLN. The Human Rights Law Network is an organization with an aim to create a justice delivery system that is accessible, efficient, accountable, affordable, and pro-poor. HRLN views the legal system as a crucial instrument for realizing human rights, but they recognize its limitations. Seeing the struggle of the marginalized, they participate in the struggle too through various activities including public interest litigation, advocacy, legal awareness programs, investigations into violations, and publishing Know Your Rights materials. Speaking on behalf of HRLN today on the topic of the occupational safety hazard and working code, we have with us Advocate Shubham Kaushal. Advocate Shubham Kaushal is a human rights lawyer in the Bombay High Court. He works with cases that pertain with the housing of urban marginalized communities, rights of persons with disabilities, environmental and service laws, and labor and governance issues. He graduated from the Gujarat National Law University, Gandhinagar in 2014 and was a part of the Human Rights Law Network Mumbai from 2017 to 2019. At present, he is engaged as a research and advocacy fellow at Ajivika Bureau, Ahmedabad, where he deals with occupational health and safety issues in the garment and textile industry and urban inclusion of migrant workers. So, we are incredibly happy to have you with us today. And before we begin, I would like to remind the NSS volunteers here that for the purpose of your attendance, you have to comment your name and your college name as early as possible, that is at least before 4:15 in the YouTube live chat. Take a screenshot of it and upload that screenshot in the feedback form, which will be made available at the end of the session in the YouTube description and in your WhatsApp groups. All right. With that, so you may begin your session.
Well, Neil, thank you for such a warm introduction. Uh, I'll be taking your session on occupational safety, health, and working conditions code 2020. So now this code it's basically a consolidation of 13 legislations that currently cover working conditions issues and seeks to repeal them. So far it's received as of date it's not been it's not come into effect, but it has received the president's assent last year 28th September 2020. But in the meanwhile the draft rules have been put out for public comments on 19th of November last year. So the laws that it seeks to subsume are so just to name them, the Factories Act, which is one of the most important laws on this aspect, the Plantations Labor Act, the Mines Act, Working Journalists and Other Newspaper Employees Conditions of Service and Miscellaneous Provisions Act, Working Journalists Fixation of Rates of Wages Act, Motor Transport Workers Act, BD and Cigar Workers Conditions of Employment Act, Contract Labor Regulation and Abolition Act, Sales Promotion Employees Conditions of Service Act, Interstate Migrant Workmen Regulation of Employment and Conditions of Service Act, Cine Workers and Cinema Theatre Workers Act, Dock Workers, Safety, Health and Welfare Act, and Building and Other Construction Workers Regulation of Employment and Conditions of Service Act. So here, like I said, Factories Act is one of the most important acts over here, but that does not take away that there are certain other acts as well, which have their own journey that they had been eventually passed and cover a wide variety of organized and unorganized sector workers who are at a very different footing. So there's a very ambitious task that this code seeks to fulfill. So and one has to also remember that when we talk about health and safety issues, these are basically non-negotiable issues, and they're akin to fundamental human right within every person who works for a living. So this is a very ambitious code, and we have to we have to keep that in mind. So I'll mostly be focusing on contract labor and interstate migrant workmen and BOCW over here. uh, so so to begin with, I think I'll just shed some light on the important definitions which basically form the foundation of this act. So first of all, where does this act apply to? So so we're looking at factories and establishments here. So this code applies to all establishments where 10 or more workers are employed. And in case of factories, for the purpose of registration, a factory will be considered an establishment where 10 or more workers are employed. Otherwise, for the purposes of the code, the threshold of applicability to factories has been increased from 10 or more workers to 20 or more workers if manufacturing process is undertaken with aid of power, and from 20 or more workers to 40 or more workers if manufacturing process is undertaken without the aid of power. So then the next part is apart from these threshold limits that have been provided in the code, in case where states have prescribed different threshold levels, those will prevail until the state amends them to bring in line with the code, or does not wish to do so. And over here, some jarring exclusions to shed light on them would include hotels and eateries, e-commerce, uh, power looms, bricklins, and micro units. Like I said, it applies to 10 or more establishments where there are 10 or more workers. So it's micro units where machine repairs take place, or garment manufacturing units, and so on and so forth. Then let's move on to the definition of occupier. So largely it is the same definition as Factories Act. Uh, and also it goes on to uh, with respect to persons having ultimate control over the affairs of the factory. And in case of a company, it could be any one of the directors except the person appointed as an independent director. Now, in case of government owned companies, it will be the person appointed to manage the affairs of the company. They will be deemed occupiers. Now, another important definition here is the manufacturing process. Now, this is important because it's been expanded from the existing definition under Factories Act. It's the expansion is in terms of the power given to the central government to notify additional processes at any time. But it also includes certain technological advancements in, especially in composing of printing activities such as three-dimensional and four-dimensional printing and prototyping and flexography. So we would have all heard about 3D printers. Then with respect to employee and worker, this is one very important aspect. So employee is a completely new category that has been introduced by the codes. And the codes seek to bifurcate workers into two categories of employees and workers. So employee is a comprehensive category. It includes any person employed on wages by an establishment, either directly or through a contractor, to do any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical, or any other work, as well as those persons declared to be an employee by the appropriate government. But there are certain exclusions here as well with respect to mine workers that are not covered under the definition of employee. Uh, then, when we come to the definition of worker, so worker is a sub is envisaged to be a subcategory of employee over here. It covers all those that are captured in the previous definition with definition of employee, but it excludes persons employed mainly in managerial or administrative capacity. And second, supervisory capacity drawing in wages in excess of 18,000 per month, or such an amount that is notified by the central government from time to time. Uh, and also another important thing is that working journalists have been brought within the definition of worker here. So now if we look at the definition of worker under Factories Act, and so it's a very widely worded definition, and it has been interpreted so by various judgments and orders of Supreme Court and High Courts. But the exclusions here that this code brings in would be first, management and supervisory workers who were covered under the Factories Act now stand excluded from the definition of workers. Second, workers employed without knowledge of principal employer or incidental to the manufacturing process within the factory are excluded as well. Then third, and very importantly, agricultural workers are excluded. And we have to remember that agricultural workers constitute nearly, if not more, 50% of the country's workforce, existing workforce. Then next we come on to contract labor. And this is also very interesting because a completely separate definition has sought to be provided by by the codes, uh, and the intent is to give a lot of flexibility here in terms of the work engagement. So if we look at the definition, it says that contract labor is a worker who will be deemed to be employed in or in connection with the work of an establishment when hired in or in connection with such work by or through a contractor with or without the knowledge of the principal employer. And it also seeks to include interstate migrant workers. But also it provides certain exclusions. So it excludes those who are regularly employed by the contractor for any activity of his establishment on mutually accepted conditions of employment and gets periodical increments, social security, and welfare benefits. Now, this is very interesting. How this plays out, we'll see this as we go move on to the further provisions. So then, since contract labor also mentions interstate migrant workers, if we look at the definition of interstate migrant workers here in the code, it is interesting that while it includes it in contract labor, it still seeks to provide a separate definition. Uh, what it does is one good thing was that that had been a long-standing demand of that had been a long-standing demand had of those interstate migrant workers who migrate on their own will and seek employment on their own without any contractor being involved. So they have been included under this, but it still excludes intrastate migrant workers. Now, intrastate migrant workers who travel within districts or from one district to another, and these, if we look at the census, 2011 census of internal migration, 88% of those of internal migration is constituted by intrastate migrant workers. So this is still a big gap by the in the code. Now, if we now one more definition that this code provides is core activity of an establishment. Now, this is also something new that the code seeks to do. The Contract Labor Regulation and Abolition Act 1970 did not have a specific definition on this. So what it while it defines what core activity of an establishment is, it excludes sanitation works, security services, canteen, loading and unloading activities, maintenance works, housekeeping, and most importantly, any activity of an intermittent nature, even if that is a core activity of the establishment. So, under the Contract Labor Act, how it was determined whether an activity is a core activity was based on 3-4 conditions given there. Uh, One of them being whether the work is similar to that done by regular workmen in the establishment, then whether it is perennial in nature. In some states, that work could even constitute up to 180 days in the preceding 12 months, and also work or process that is necessary or incidental to the work, trade, occupation carried on in that establishment. So this definition of core activity is a clear departure from the intent, the very fabric of Contract Labor Regulation and Abolition Act. Um, then if we look at the definition of contractor, it's more or less similar to the definition in the act that it seeks to repeal, but also it adds a term as mere human resource, which how it plays out we'll have to see. Then when it comes to the definition of an employer, there is a very expansive, broadly worded definition that seeks to provide, uh, which is a really good progress in comparison to the previous legislations. It covers persons having ultimate, one of the clauses in the definition is persons having ultimate control over affairs of the establishment. So this gives a very wide ambit, and it expressly obviously also includes a factory occupier, contractor, and in case of an establishment such as a government undertaking, the specified authority or otherwise the head of the department under which the establishment is run. And something new that this goes on to add is legal representatives of a deceased employer. This was not seen before in any of the laws. And then moving on to building or other construction work. So this is also interesting because a Building and Other Construction Workers Act of 1996 was, there was a whole journey, very hard-won journey behind it to get a very expansive legislation. But while defining building or other construction work, there are exclusions at two levels that have happened here. First is that building or construction work related to factories or mines is not included. And second is that work for residential purposes, where the total cost of work does not exceed 50 lakhs, has also been excluded. So apart from the definitions, another, of course, important aspect that we have to consider is the duties of the employer that have been given here. So there are a range of responsibilities, including providing a safe working environment, adequate welfare facilities such as restrooms, shelters, creches, uh, separate facilities for transgenders in all establishments, uh, which are a continuation of the previous legislations, except separate facilities for transgenders, which is a new progressive step. Uh, Apart from this, it also talks of providing free of cost temporary living accommodation for all building workers. And also it has reduced the threshold for providing all of these facilities. So while, like for instance, while earlier for provision of shelter, it used to be 150 workers in an establishment, now it has been reduced to 50 or more workers. So that is also a very, welcome step here. But there is still a drawback here. While it gives broadly gives these duties, it does not prescribe any standards. So like standards for occupational safety and health haven't been prescribed, working conditions haven't been prescribed, facilities for workers haven't been described, like the standards haven't been laid down explicitly, which was done in, say, Factories Act, which was done in the uh, Contract Labor Regulation Act or ISM, Interstate Migrant Workers Act. So that is missing over here, and these are to be notified. These standards will be notified separately altogether. So we have to see how this plays out in the rules, and how these are adopted by the states, because these really, this forms the skeleton of the health and safety of workers that we seek to achieve from this code. And with respect to notice in the event of an accident or a fatal occurrence or notified disease, the same provision as the previous act continues, uh, uh, which uh, which we'll have to also see how it plays out in the rules. Then another important aspect is with regards to safety committee. Now, the constitution of a safety committee was under the Factories Act was based on a bipartite understanding, where there were representatives even of the workers and from the management board of the factory. But now the establishment of a safety committee has been left up to the government. So a government will notify a safety committee in each establishment, and also these safety committees, instead of the earlier threshold of 250 or more workers, has now been moved to 500 or more workers. So that is also one drastic change that this has brought in, and uh, and it will have very wide implications. And another interesting thing that the code does is it puts the onus on the employees to take reasonable care of their own health and safety, and other persons who may be affected by his acts or omission. But while we have all these duties, while the code places so much onus on uh, the employer and the establishment to provide all these facilities, to create these safe working conditions, there is no way to check the compliance of this in real terms. And at the same time, it also places some sort of onus on the employees. So how with respect to compliance, I will come to it in the subsequent part. So apart from the duties, now let's look at the scheme of the code, like how is the code really going to play out. So first and foremost is through registration of establishments and licensing of factories and contractors. So the definition of establishment, as I mentioned earlier, which it seeks to cover every such establishment where 10 or more workers are employed. All such establishments have to register under this code. So now if registrations, if establishments do not register themselves, then they are barred from employing any person. So so it's so that is really important for them to register. And in case where such a establishment qualifies into the definition of a factory, it also has to obtain a license. So basically for factories it's a two-step thing. So they have to register and they also have to obtain a license, and then there's a whole provision for obtaining common licenses of for various different purposes if they have different kinds of employ workers within the factory. Now, with respect to contract, so the again this registration has to be done within 60 days from the date of incorporation. So and also the onus for this, for providing all certification with respect to registration and licensing, is indirectly put on the authorities themselves. And with regards to licensing of contractors, so now there are new ways, like new uh, ways also through which mechanisms through which contractors can obtain licenses. They can also have work-based licenses. They can also have national licenses, which was absent earlier. Then if we come to the working hours, so under the Factories Act, it was 9 hours. Now it has been reduced to
It would seem like Shubham sir's electricity has gone. So we'll contact him and we'll ask him if he can switch to his mobile network to complete the rest of the presentation. So give us a few minutes while we see if he has an alternative device to use at this point. All right, Sir is making arrangements for another device and to use his mobile network. So kindly be patient while we bring him back. In the meanwhile, if any of you have any questions about what you've been hearing, if some of the dots do not connect for you, and if you want a further explanation, even if it's a basic question, that is all right. You may ask your question on YouTube, and we shall ask him the question on your behalf. Welcome back, sir.
Yeah, sorry about the interruption. So I'll just jump right back.
Um,
So
so before you do, if I could just ask you just a few questions. So you've spoken about a lot of the changes and you've spoken about how there will be consequences, but I believe some of the students in the audience might have a little difficulty visualizing the impacts of these changes. So if you could just give us an example wherein you put yourself into the mind of like an employer. So a lot of these codes they're brought in with the idea that this is for ease of business, right? So if the threshold, say for one of the changes is that it's gone from like 10 people to 20 or 20 to 40, as an employer who's like employing 10 people and I'm going to go up to 11, what is it that I do not have to worry about now that I would have had to worry about before these codes were there? Could you just give an example so that we can see how the behavior changes here.
Yes, I can try to include that here going ahead. Now, I'll just jump right back into working hours that I was referring to, and I'll also include what you mentioned. So, like I was saying, under Factories Act, there was the provision was to provide 9 hours of work, and it has been reduced to 8 hours, and it also includes rest. And so so with respect to also the prescription of timings, shifts, holidays to be provided over time, all of these have been delegated to the appropriate authorities. So there is no specific provision on this. uh, and at the same time, authorities can also provide exemption from all of these conditions. So another thing about this is, with respect to every case that there is a overtime, the worker would be entitled to twice the wages that he's normally entitled to. So that is also one new thing that has been incorporated over here. And earlier there were certain restrictions on women workers which were there in the Factories Act, where they were not allowed, where it was not allowed to work more than 9 hours, and between 10 p.m. to 5 a.m. So these restrictions have also been removed. Now, if we go on to obligations that an employer has towards contract labor, so so this code would apply only in cases where there are 50 or more contract labor employed in an establishment with respect to contract labor. uh, and like I was mentioning earlier, so with respect to the definition of core activities of an establishment, there is a broad exception to the prohibition of employment in core activities, which is given under Section 57 of the Code, which is actually, unfortunately, a departure from the fabric of the Contract Labor Regulation Abolition Act. Now, another thing over the act is the new code provides is the onus of providing basic facilities and welfare facilities to contract labor, which was earlier on the contractor, has now been moved to the principal employer. But the onus of payment of wages, it still rests on the contractor. So but these payments have to be made through bank transfers or electronic mode. So, so the problem here again is that a lot of contract workers and a lot of do not. It entirely excludes those who cannot obtain bank accounts, or their format of work is such that it impacts their mobility. So also another thing that the code has done is it's removed time limits to so earlier in Contract Labor Regulation Act there were time limits within which uh, certain obligations had to be fulfilled with respect to, say, provision of facilities, provision of social security or basic amenities, or even timely payment of wages. So all of these have been done away with in the code, and along with the supervision of payment of wages by a representative of a principal employer, which was provided in the previous act, it's now been done away. Now, if we move on to interstate migrant workers, there is again a separate chapter on interstate migrant workers that this code contains. This chapter is unlike Contract Labor Regulation Act, unlike the previous chapter on contract labor. This chapter on interstate migrant workers is applicable to all establishments where 10 or more interstate migrant workers are employed. These So all of the so one of the most important thing which has been continued from the ISMW Act is that all of the benefits that are available to other workers, other types of workers in the establishment, including social security benefits, such as Employee State Insurance Act, they will also be extended to interstate migrant workers. Journey allowance has also been specifically provided for. However, displacement allowance has been removed. Then also another part over here is that while the definition over here is very expansive, but the provision of basic facilities and welfare is only through an employer, only through an establishment, which again excludes this whole category of casual daily wage workers who do not work through the contractor. So and that includes a very vast category of interstate migrant workers. And again, another part of this is with respect to portability of availing benefits of the public distribution system. So uh, again, this portability is not made universal. So either an interstate migrant worker will have to opt to take the benefit in his home state, or he will have to take it in his destination state where he is employed. So that again excludes an entire gamut of interstate migrant workers. Then, if we talk about how, so what the act, what the code seeks to do is it emphasizes on facilitating and ensuring compliance as against penalizing employers, which is a big departure from, it's a fundamental fabric departure from previous legislations. So how this is done is, I'll just quickly, like briefly list it out. So first and foremost, this provision of inspector come facilitator. So earlier it was only inspectors. Now they've also been given the title of facilitators. So their function is mainly to ensure compliance, to help, to assist, to sensitize employers to the provisions, and to facilitate in the compliance. So also, when we look at the inspection provision under the act, so the inspection is now the physical, the power to go and physically inspect premises have been done away with, and now all of the information with respect to all of the inspection has to be done by way of done electronically. So the mechanism it provides is that, on a draw of lots basis, certain establishment will be selected. So and their information will be called electronically. So essentially it takes everything into electronic recording also. And also another thing that benefits employers here is that they are given an opportunity to rectify before they are penalized. So and this is a time bound opportunity within which they have to do all this, any sort of discrepancy or violation that the inspection may disclose. Then another interesting benefit here is the compounding of first offenses before prosecution. So the first time any offense under this act has been conducted has by an establishment or an employer or a contractor, uh, they can be compounded by way of payment of 50% of the maximum penalty in case it's a penal offense, or 75% in case of 75% of the fine in case it is an offense. But the second and the third time they would have to incur the penalty that is laid down under the code. Then again, very wide powers that have been provided here to appropriate authorities is to exempt from any of the provisions under the code. So, as we had seen during the pandemic, during the lockdown, how certain states had, like, say, for example, Gujarat or Uttar Pradesh or even Rajasthan, they had uh, notified certain, they had made certain exemptions, they had notified with respect to work timings and other certain provisions. So, such sort of exemptions have now been authorized by this code. And then another part is with respect to exclusion of jurisdiction of civil courts. So now if there's any sort of recourse that the employer or employee or worker wants to undertake, has to be through the settlement mechanism and the authorities provided under the code. So that is also another feature of this particular code. And just to I'm not going to go on the penalties, because they I mean, it's just laid out uh, in very explicit figures how the mechanism for penalties has been provided there. Just to focus on some important aspects of this code before I wrap up my presentation, is one that one point that is actually very crucial and is missing, is that under the Factories Act, uh, so Schedule 1 provided maximum permissible threshold limits of exposure to chemicals and toxic substances in manufacturing processes. So they have been omitted over here. And like I was mentioning earlier at the beginning of my presentation, that this is a kind of a code that seeks to cover health and safety issues for workers, which are in a way very fundamental to their very being, uh, which are fit to be categorized as fundamental rights. And also uh, so 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 this is a very big, so to say, loophole or a misstep that the code does. Yeah, I think that's all I'll be able to shed light on here. So
All
if
right.
there are any questions, you can let me know and I'll see how.
So there is one question from Prashali. You mentioned that the restriction for women's working hours, that is from 10 p.m. to 5 a.m., has been removed. She was concerned as to what sort of alternatives there are for her safety at this point. Like, does the corporation that now employs them between these timings, is there any burden on them to secure a woman's safety?
Yes, so while it does away with those restrictions that were earlier there, it also puts an onus on the establishment to provide for security and other facilities, welfare facilities, such as shelters. But again, the code does not give lay out any standards on what these facilities and these security provisions are going to look like. These are still standards which are yet to be formulated, and which we'll have to see in the rules how they have been notified. Uh,
Okay. And these rules that will be notified will be done by each state government?
so the central government will, as I mentioned earlier, on 19th November, the central government did put out in public the draft rules under this code, and every state is also in the process of notifying its own set of rules as they seek to adopt them. And yeah.
All right, okay. So if I could go back to what I'd asked you initially as to whether you can give certain examples for these scenarios so that it's easier to visualize. Like from an employer's point of view, with the object of the act is for ease of business. So as an employer, what kind of ease am I actually going to face after these changes? If there's something like that you can elaborate on.
So, like I mentioned, one of the things that this code does is there's a common license procedure. So the common license procedure is more like a single window clearance mechanism, where all sorts of licenses for employing different kinds of workers applicable to whom this code will apply can be gotten in one single license itself. And the other uh, another aspect that I had mentioned was also with respect to the inspection, how it's undertaken. So far, uh, the inspection would usually be taken in the form of physical inspections, which are not notified prior, and they would become they would perhaps become a mechanism for inspectors to unduly obtain favors from the establishments and factory occupiers, or they could even become a form of bribes, which was a big uh, issue that was not that had not been dealt with so far, and that could not be no proper way out of it was being figured out. So the code in a way seeks to address that by providing for inspection uh, and through electronic means. So there are only very few circumstances. So it does not envisage the entire machinery is taken online. So it does not envisage any need for a physical inspection. So that barrier is created between inspectors and establishments.
All
And
right.
also, yeah, so in like basically the code itself is it's gone into a more like a compliance, a facilitative setup, a scheme for establishments to be able to you know run.
So this digital infrastructure of the inspection has to be implemented by each state government or the central government or the companies. How is it working exactly? Any clue onto that?
So the code is not very specific about this. It just says that the appropriate authority has to lay down. But I can give you an example of Gujarat, where here, since the last couple of years, the state government itself came up with a policy where, which is called also, which is titled also somewhere around single window clearance policy. Uh, it somewhat is already like this mechanism where the inspections by the labor inspectors and factory inspectors is done on the basis of a draw of lots. So it's not so it takes away that um,
Yeah, all right. So at this point, then we could say that even if there are loopholes that you've pointed out that are there in the skeleton structure of the codes right now, it is possible for the state governments to step in and plug those holes for for the employees and for the employees and for the whole system, right? Is that how it would work? Like, is
so
it possible?
So
Yeah,
absolutely. I mean, it is after all, labor is on the concurrent list. So the states also sort of have the legislative capacity under the constitution to do so, and we have also seen in the past. But the whole point of bringing in the code is to bring a uniformity of standards throughout the country. And like I also mentioned earlier, the ambition of the code is also to bring workers both from the organized as well as unorganized sector in a way at par when it comes to occupational safety and working conditions. So there is a need for like that uniformity of standards in a way, at least as per the code.
right. So uniformity was an issue that was brought in the previous lectures as well, where I think we were discussing the idea of floor wages and minimum wages, and the idea is that the central government puts a floor wage, and then when the state governments assign different minimum wages, of course, because the societies are different, their standards of life are different. What happens is that certain companies will go to those places where there's a lower minimum wage, so that they don't have to pay as much once they set up there, and so in that way does affect what kind of establishments are more prone to go to which state. So even over here, say if we have the skeleton structure now with the wage code, now if one state government does not plug in as many loopholes, that gives in more leeway, I guess, to the employers to get away with more things, as opposed to a state legislature that is more regulatory. So even though there is an attempt to get some uniformity, do you think this would cause issues in where companies choose to go?
Uh, So yeah, like very interestingly that you pointed out. So again, like the applicability of all of the codes is eventually decided by the threshold that is set in the definitions, right? So far also, if we have seen all of the acts, it's like be it a factories act, be it contract labor or interstate migrant workers, or building and other construction workers act, every act has different threshold levels. How many workers will an establishment or will a factory need to qualify for that act to apply to them, right? So that discrepancy still exists even after the. So we'll have to see how I mean, what kind of engagement does every state have while it formulates its rules, and what processes does it adopt to formulate them, which will actually uh, uh, set the path for companies to or employers to understand what kind of obligations will they have to incur in one state as against another state. So really it's sort of putting the onus on the employers as well to figure out where it will be more favorable.
Right. So there's a lot that's still left for speculation. So I guess there's going to be a whole lot of series of webinars coming out after more legislation comes through. Maybe this is not the best time, but understanding that the definitions is still very important. So we'd like to thank you for coming on board and helping us understand like the basics right now that have come out from the center. And would you like to provide any closing statements?
Uh, well, that's all. I think just to remember that this is a very fundamental aspect that perhaps affects all of us in ways that we haven't yet understood. So we should engage with this at in different ways that we can, while states are in the process of formulating rules currently.
Right. So I guess as the people of each state, we can put some sort of pressure on the state government, make our demands known, make them known what kind of regulations we would like to see in spite of what the center has put through. And that starts with being well informed on what the center has put through in the first place. So we hope that the audience has liked today's session. Unfortunately, we do not have as many questions in the YouTube chat. So I would like to move on to the vote of thanks, and I would like to call on Shreya for that.
Thank you, Neil. Good evening, everyone. I, Shriya Maman, would like to take the opportunity on behalf of the Government Law College National Service Scheme Unit to thank Advocate Shubham Kaushal for enlightening us with his information today on the topic of occupational safety, hazard, and working codes. It was definitely a very informative session, sir. And thank you for giving us the opportunity to invite you as our speaker today. I would also like to thank Niranjan sir for giving us the opportunity to organize this series of webinars in collaboration with HRLN and for being very cooperative and helpful during this whole process. I would thank our principal, Dr. Rohidas Kare sir, our programming officers, Professor Kritika, Professor Duffel for constant support. And lastly, I would thank all the NSS volunteers, students, and professors, and everyone for attending today's webinar. And I hope that you all also attend tomorrow's webinar, that is the last webinar of the series at the same time on the same platform. Thank you.
All right, guys, you may all leave. The feedback link is available now. You can fill in your forms within the next 10 minutes. Thank you. Goodbye.
Thank you.